You believe your doctor was careless and caused you significant harm and injury. You go to an attorney who confirms after having your medical records reviewed by an expert that yes, you have a valid basis for a case. But you are a very, very private person. You never, ever like to disclose any of your medical issues with any of your friends or family. And you are horrified to learn that if you go ahead and bring a lawsuit, your entire medical history is going to be an open book. What do you do in that instance? Would you like to know the answer? Come join me for a walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is you do one of two things. You either go forward with a case or just the opposite. You don't. Now, you believe that your doctor was careless and caused you significant harm and injury. You go to the best attorney you can find. The attorney goes ahead and obtains all of your medical records and now has a great medical expert, a well-qualified medical expert review your records. The expert comes back with an opinion, and the opinion is that yes, your doctor violated the basic standards of medical care, and as a result of that, you suffered significant harm and injury. You will now have lifelong permanent disability as a result of this carelessness by the doctor. Now, we're not saying that the doctor intentionally caused you harm, but rather that the doctor was negligent, was careless at this particular time, on this particular day, and as a result of that carelessness, now as we watch the jet skis go by, and as a result of that carelessness caused you significant harm and injury. So now your attorney has confirmed with a medical expert that you do have a valid basis for a case. And you are now glad that you are going forward with a case. But once you learn of this expert's opinion, your attorney tells you, listen, during the course of your lawsuit, he will have to provide permission slips, what we call authorizations, to the defense, the attorney who represents the doctor and the hospital, to obtain your medical records. They will be allowed to review and read every part of your medical record. In fact, we will have to provide the defense with copies of all the medical records that we obtained on your behalf in order to review your case. So not only do we provide copies of your records to the defense, but they will also want to get those records directly from the hospital and the various doctors. Why? Because they don't trust us. And even if they do, they still want to verify exactly what's contained in the records that we provided to them. You tell your attorney that under no circumstance do you want your private medical condition and medical issues revealed or released to the defense. You tell your attorney that you are such a private person, you would be horrified to learn that someone else knows about your medical problems, that someone else now knows that you are disabled and you are limited from doing your daily activities. You create this great persona and personality around what you do and what you have done in the past, that the moment anybody outside of your small circle of just yourself realizes that you really are not the persona that you created and now have disabilities and limitations and are unable to do many of the things you claim to have done, guess what? Now your reputation will go downhill. Now your business will suffer. Now people will look at you differently, and your perception of how they perceive you will be totally different. You believe that you will be shunned from your social outings. You believe that no one will want to hang out with you. They will not want to go to dinner with you. They will not want to do things with you. And as a result of that, you tell your attorney, under no circumstance are you going to reveal any of those medical issues to anybody else. Now, your attorney tells you in very clear, unambiguous terms, if that's really how you feel, then I can't continue to represent you. I am obligated by law to provide medical records to the defense so that they understand what issues you have, what problems you have, what limitations you have, and everything that's contained in your medical records, including your past medical history. It doesn't matter what happened to you in the past. It doesn't matter what things occurred to you in the past. This now all becomes an open book. And if you tie my hands and prevent me from releasing this information and from giving the defense permission slips, authorizations to go ahead and get your medical records, I cannot ethically and properly represent you. In that instance, what I highly suggest is not going forward with a lawsuit, because I will not be able to effectively and properly prosecute your case? Because if you tie my hands and don't allow me to do this, guess what? You are now hamstringing us. You are now preventing me from doing what I am obligated to do. And now you're creating roadblocks and obstacles that will create enormous problems for you and your case, and will incur the wrath of the judge as well as the defense, but most importantly, the judge. If that is really your belief, my suggestion is do not go forward with a lawsuit, because you will be miserable during the entire time that your case is being prosecuted. You will be miserable when the defense attorney now has to ask you hundreds and thousands of questions about what happened to you, about what injuries you suffered, about the damages you now incurred as a result of the doctor's carelessness. In that instance, my strong suggestion would be don't go forward. On the other hand, you may be able to overcome that reluctance by understanding that this is your one and only time to obtain money as a form of compensation for all of the harms and losses and damages you suffered because of this doctor's carelessness. So that's something that only you can answer about whether or not you can still proceed forward, knowing that this is your one and only opportunity to go forward. So why do I share this quick information with you? I share it with you because this does come up from time to time, where I have a potential client who now is so concerned about how they are perceived in the community and amongst their family, and they are horrified to learn that all of their medical issues will now be an open book to the defense attorney. And now they'll be questioned about it at great length, and they just don't want to do that. You know, I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter happened in New York and you have not yet started a lawsuit but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.